you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000, personal recognizance, not to operate or be in the driver's seat of another vehicle. Did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean?
Today's video is a triple feature in courtroom chaos. 3 defendants, 2 furious judges, and 1 recurring theme. When stupidity meets the legal system, everyone suffers. We've got a repeat offender who thinks traffic laws don't apply to him, a foul-mouthed driver who forgot she's not at a pub, and a man convinced that every courtroom in Michigan is secretly conspiring against him. What you're about to watch isn't just legal drama. It's a masterclass in how arrogance, ignorance, and misplaced confidence collide under the fluorescent lights of justice. Stick around, because these judges don't just hand down rulings. They hand out reality checks.
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here. Sir, come. Get out of here.
This judge doesn't just command respect. He demands accountability. Listen to his tone, calm but boiling under the surface. He's seen this defendant too many times and is done playing babysitter to a grown man who treats court orders like casual suggestions. Notice the phrasing. You might as well just walk to jail. That's not frustration. That's final warning territory. What makes this moment so powerful is how personal it sounds. Like a disappointed parent instead of a judge. And that's what makes it sting even more. When a judge says, "I can't believe I'm letting you go," that's courtroom speak for, "I'm out of patience and you're out of luck."
Michigan versus Bradley Peterson. Okay, counsel, you're Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson? For the record, please.
Brady Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right, and so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court.
This transition is brilliant. We go from one idiot on bond to another disaster waiting to happen. But what really sets this scene apart is the setting. A courtroom full of kids. Imagine your field trip to the courthouse suddenly turning into a live demonstration of Actions Have Consequences 101. The setup is pure irony. These kids came to see justice in action, and they're about to get a front row seat to the definition of
Be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court.
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript. You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had
And there it is, the moment she torpedoes her own case. You can hear the shock in the judge's voice when she drops the profanity bomb mid-sentence. This isn't just disrespect, it's career-defining stupidity. The judge's reaction is priceless, immediate, righteous, and perfectly timed. He doesn't raise his voice or argue. He just cuts her off and orders her straight to jail. No lectures, no warnings, just a swift reminder that courtrooms are not debate clubs or TikTok live streams. What's poetic here is that she walked in to turn herself in anyway, and still managed to dig herself deeper. Some people don't just trip, they dive.
Also, a request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17th, and you're requesting our 2.003 to dismiss, disqualify the judge as follows. File the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Winnebago Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that that's a condition this court put in because that's what's alleged, as a violation. So to protect the complaining witnesses, that's what the court put in, just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Now we're shifting gears to Michigan. And right away, the energy changes. This isn't chaos. It's quiet tension. The defense attorney is trying to make a graceful exit, and his reasoning says it all. His client's strategy is so off the rails that it's putting his law license at risk. That's when you know a case is bad, when your lawyer wants out. The judge handles it tactfully, but the subtext is clear. This defendant isn't just difficult. He's a walking legal migraine. It's a textbook example of how self-representation can go from bold to...
Please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you, man.
The allegation is that you assault or resisted, obstructed a police officer causing injury and trespassed.
That's
Now,
just an allegation.
you're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Here's where things get hilariously tragic. The defendant starts quoting legal procedure. Badly. You can almost hear the collective facepalm when he insists he needs to file a motion for a transcript. The judge, trying not to lose patience, calmly explains that you don't need a motion. You just pay a fee. But this guy's too deep in his pseudo-legal rabbit hole to understand. This is the kind of courtroom moment where delusion meets bureaucracy, and bureaucracy wins.